is a California case, and 187 is the code for murder in California. And that expert testified that in the gang culture, 187 is the functional equivalent for saying killing somebody, for saying murder. So the point there was that the jury did not have to speculate as to the meaning of 187. It was given a unique meaning. Here, it is quite the opposite. The jury will be forced to speculate as to the meaning, to draw an inference on top of an inference on top of an inference. So the facts here are extraordinarily important. The witness, Mr. Nelson, testified that he did a tattoo, put a tattoo on Mr. Hernandez that had 5 unspent bullets and 1 empty chamber. So by unspent bullets, the testimony was that there were bullets inside the shell casing, inside the chamber, with 1 empty space. Let me pose a brief counterfactual with the court. If there had been a tattoo on Mr. Hernandez with 5 empty chambers and 1 bullet, I submit that the Commonwealth would be making the same argument, that this is some sort of an admission that he expended 5 bullets. The very opposite, they're making the argument now. So in order for this argument to make any sense, there are 5 unspent bullets. The fact finder would have to assume that this was, and infer that this was a statement about, well, statement 9 months after the fact that pointed to an instance before a shooting where the chamber was fully loaded. They would have to further infer that he meant to indicate by that he at some point in the past expended those bullets, thereby emptying or spending the chambers. And
I'm sorry, are you talking about the tattoo as it was imprinted here, or your reverse?
I'm talking about the tattoo as it is printed here. So here, there's unspent. So the jury has to believe that the statement, if there is a statement, is that 9 months earlier, that tattoo represents a point in time before the decedents were shot, and that some point shortly thereafter, the decedents were shot with that gun, and that the bullets left the shell casing. That, by definition, is an inference on top of an inference on top of an inference. The point of the counterfactual, Your Honor, seems to me the counterfactual is a much closer case. I would argue that it's still not sufficient. But the counterfactual, if there were 5 spent shell casings and maybe 1 empty one, would be closer.
How do we know if they're spent or unspent?
Well, that's the only thing that was on the testimony that came out from the witness stand today. And Your Honor can check the transcript if you like, but the proponent of the evidence, and I can't remember if it was Mr. Lee or not, the proponent of the evidence asked the witness specifically, and the witness said that there was bullets inside of a shell casing. That's the only testimony.
Well, that is not on the tattoo, is it?
Pardon me?
It is not on the tattoo.
Presumably, that's what the witness saw from the rendering on the tattoo. Presumably, it would look different if it weren't. That I've used presumably twice is another example of why this is an inference on top of an inference on top of an inference.
Okay. The tattoo shows what appears to be the cylinder of a revolver. It shows the firing pin and head of 5 shells. It shows 1 cylinder, 1 slot of the cylinder unloaded. I don't think it shows more than that, and then 3-dimensionally shows some contour to the side of the cylinder to give it depth. It doesn't show whether these shells are in fact intact or spent.
Well, that's what I would quarrel with Your Honor about. The only testimony we have is
where are the photos? You would quarrel with that description of the tattoo?
I would quarrel with what is in evidence, because the only thing in evidence, well, two things are in evidence, the picture and what the artist said.
I'm asking about the tattoo itself.
Yes. And
have I accurately described the tattoo, Mr. Sullivan?
In the context of the testimony that was given, I don't think so.
Of the tattoo?
Correct. The witness expressly said that the bullets were in the shell, and that was not challenged by the government. Certainly wasn't challenged on cross-examination.
All right, I've been given items that don't show what we want. Are there photographs, Mr. Sheehan? Thank you. All right, I'm just looking at what was marked Exhibit 4 for purposes of the hearing, and how, Mr. Sullivan, one tells that is an unspent as opposed to a spent shell.
I don't know. That is what the witness, the artist, testified to. So at present, that's the only description in evidence.
Okay.
And so that's the only description in evidence. Now, the following is not in evidence, but if it were a spent shell, they would have dimples on them from the firing pin, and there appears to be no dimples there. But again, none of this is in evidence and would require speculation. But as I look at it,
no, this is in evidence.
None of what I just said is in evidence.
Yeah.
But as I look at it, knowing about guns and having litigated gun cases for the last 25 years, a spent shell would show a little dimple from when the firing pin hits it. That's not present there. So if there is any inference to be drawn from things that are not in evidence, the inference is that these are unspent, which seems antagonistic to the government's theory. If the government's theory of admission is that this is an admission that he shot 5 times, then having a cylinder with 5 unspent rounds is antagonistic to that theory and will require the jury to speculate and infer and do the sorts of things that aren't allowed. This is in clear contradistinction to a case like Ochoa, where there's only one possible meaning established by expert testimony. Second, Your Honor, in addition to the jury being forced to speculate about whether the shells are spent or unspent, and if they are unspent, whether this is a statement about a time period preceding the shooting, and then a shooting was going to happen, it becomes extraordinarily confusing. But beyond that, Your Honor, there's the issue of whether 5 or 6 bullets were actually expended at the shooting. The overwhelming majority of the testimony thus far is that there were 6 shots. Brian Kwan testified 6 shots. Donald Gobin testified 6 shots. Sanchez says 6 shots. Much of the testimony thus far has it at 6 shots. So what does 5 show? It certainly doesn't match the overwhelming majority of the testimony. Paige Aiello said 3 to 5 shots. Gave a range, but with 5 as the top number. Jamie Furtado, 4 to 5 shots, again a range, but the government cannot submit by fiat that 5 was the number of shots and then bootstrap in this so-called evidence of a tattoo as proving that 5 shots were shot when what's in evidence simply does not show that as of yet. So that, Your Honor, or those arguments, Your Honor, constitute the prudential argument. That is, that this court should not expand Massachusetts law by using this as the test case as to when a tattoo comes in as an admission. Now, the traditional use of a tattoo in Massachusetts is that they have come in for identification purposes and or for gang affiliation cases. And even under that lower evidentiary standard for gang and ID purposes, the facts here still don't meet those standards. So in Massachusetts, under the traditional admission requirement, the courts here are very careful about inferences. And in, for example, Poirier against Plymouth, that's 372 Northeast 2nd, 212, the court says inferences must be reasonably based on probabilities, not possibilities. That it is probable that these unspent shell casings, or at best ambiguous shell casings, are an admission of something that happened 9 months ago, when the testimony from the witness stand was that Mr. Hernandez said very little. He sat there with headphones on, said very little, and it was ambiguous at best as to who chose what off the internet. There was inconsistent statements there. Your Honor has all of those. But the point is, there was nothing in the context of the interaction with Mr. Nelson that would lead a court to say there's a probability that this sort of evidence is an admission. And the reason the courts have been so strict, even on this lower standard, is that under Mandile, for example, 403 Mass 93, the court said that this cannot be, quote, a product of conjecture or speculation or the piling of inference upon inference. That's Commonwealth against Mandile, Your Honor. And the cases go on like that with respect to the gang affiliation ID. Now, we're submitting that there's an even higher standard to the degree that the Commonwealth seeks admission of this evidence as an admission for Mr. Hernandez, and that they're not even particularly close there. And there's a final constitutional argument.
Well, is this now argument number 3?
This is argument number 3.
All right, so the inference argument is number 2. And I take it you would apply that same argument as to the reasonableness or probability related to inferences to a claim that this is consciousness of guilt evidence.
Oh, indeed.
In the same way as you're arguing against an admission.
Indeed, Your Honor.
Okay.
So you as an admission, I submit, is a much more stringent standard. So there is nothing in Mass. I mean, it's so stringent that there's not a Massachusetts case, at least that I've been able to find, that deals with this. And the cases in other jurisdictions which may be persuasive evidence simply are inapposite to these facts. Again, Ochoa, expert testimony, and most importantly, only one option. You know, this thing is the functional equivalent. It is the proxy of something else. 187 means one thing in this context, and that's murder. The gun tattoo, Mr. Leontire showed several pictures to the witness on the internet. The witness testified that he's seen several gun pictures on the internet. He's done tattoo pictures he's done gun tattoos on human beings before, and he is aware of gun tattoos on human beings. And so unless the claim is that every single human being who gets a gun tattoo is somehow making an admission to a crime, then it becomes difficult to argue in this matter that 9 months after, with no context like in Ochoa, that Mr. Hernandez intended this as an admission. So I would separate that slightly from consciousness of guilt, which falls under area number 2. Inference on top of inference and probability rather than possibility as the appropriate way to look at that. And most of the consciousness of guilt cases, as Your Honor knows, is much more temporally related to the actual crime. It's something right before, right after the crime. Not 9 months later in a different state. Well, he's rehabbing an injury sort of thing. The temporal separation is something that Your Honor should consider.
Okay.
And the third is a constitutional issue, which is extraordinarily important in Massachusetts. So, looking at Massachusetts law and the way the criminal law particularly handles attendant circumstances, presumptions, and inferences, Massachusetts courts, under a due process analysis, is extraordinarily weary about the potential of unduly shifting the burden of proof to the defendant through what Massachusetts courts regard as highly speculative or prejudicial inferences. So whenever Massachusetts courts are dealing with presumptions or dealing with inferences, in the backdrop is always a concern about the degree to which an inference may shift the burden, or more specifically, a speculative inference may shift the burden. We submit that here, this is the very sort of speculative inference that runs the risk of shifting the burden to the defendant. Now, I would also submit that is why, 15, 20, 30, 40 cases didn't just immediately pop up about tattoos as admissions, because, this is an area where the Commonwealth, to abstract this out, the Commonwealth is using the tattoo as testimonial evidence. So we, in using this as testimonial evidence, we also have to be wary with respect to privileges against self-incrimination, both under federal constitutional doctrine, but under Article 12 itself, in addition to the potential of burden shifting. So I would, and we cited this in our original brief, Your Honor, but the cases on presumptions in Massachusetts are clear, and inferences in Massachusetts are clear that the anything that's highly speculative is frowned upon. And so, summarily, we suggest that in this matter of first impression, the prejudicial effect on Mr. Hernandez of his tattoos being used as an admission would invite the jury to make layers of inferences or layers of speculation to get from what this witness testified to, unspent ammunition, to an admission of a shooting, would prejudice him and his interests severely. This, in light of other things we've been arguing about this past week, represents a cumulative impact of prejudice on Mr. Hernandez, and the very weight of the accumulation of prejudice is going to be, or is inclined to essentially set Massachusetts precedent in the use of a tattoo as as a statement, this is not the case for it. We can imagine a case, a different case, like my counterfactual, for example, that will be a much, much closer case.
Well, suppose there were a diary entry that said, I shot Danny and I shot Safaro. And suppose that diary was connected to Mr. Hernandez. Would that be admissible?
If there were a diary interest that said it explicitly,
I shot, name the known victims.
Yeah, then that's in all likelihood an admission.
That's pretty clear admission.
Yes.
And would likely be admissible.
Yes.
And you'd agree with me that the manner of communicating, that is, of making a statement, an admission, doesn't much matter. Whether it's written in a diary, recorded on a CD, written in the sand, so long as it is connected to the author and becomes a statement of that author, then it becomes an admission by that person.
Assuming the substance is the same, yes.
Yeah. So, assuming we had a tattoo that said just the same thing, it would, at least as a matter of evidence, fall into the same principle. Whether it's a tattoo or a diary entry, it is an admission, assuming the statement itself is so clear as to constitute an admission.
Right.
What we are arguing here then is whether or not the tattoos at issue and the manner in which they were selected and then imprinted and all the attendant features and any other circumstances suffice to demonstrate that the defendant was making a statement that would qualify as an admission.
And it's the...
So it's a foundational issue more than it is a matter of constitutional significance, whether it's a tattoo or a diary entry.
No, I think that's where I would part ways. So the diary entry, I shot Danny, for example, is an admission and so forth. On the other end of the continuum, let's say an individual had a tattoo of a rifle. That's all. Nothing more, nothing less. So in the first case, that's clearly a tattoo. I mean, clearly some sort of admission, which, notwithstanding any other sort of challenges and privileges, would likely be admissible. The rifle, on the other end of the spectrum, would be clearly inadmissible and prejudicial. So, as is the case with the law, it's a process of analogical reasoning. Is this more like the diary, consistent with constitutional limitations and other, or is this more like the rifle? The law intervenes in that it tells the court how to adjudge whether one is closer to the other. And in cases where you have a tattoo, there's actually law on that. Not in this jurisdiction for tattoo as admission, but in other jurisdictions as tattoo for admissions. And the law does two things. On an affirmative register, it says that it's got to be clear, just one meaning, not subject to sort of speculation. And on a negative register... Well,
I'm not sure that a single case out of California constitutes the law of the land, Mr. Sullivan.
Well, in the absence of a Massachusetts
constitutes the law
case.
of California.
Correct.
Or at least one judge's interpretation of the law of California.
Correct. My only point there
and was
is
that
this
case,
is persuasive.
I'm sorry, was that reviewed on appeal?
I would have to check, Your Honor. The only reason I cite that case is because there's the absence of a Massachusetts case.
Yeah.
So if the court is looking for some persuasive guidance, that's fine. If not, that's fine. But on a negative register, we can look one level of analysis down, and that is using tattoo as gang affiliation. And Massachusetts courts very clearly caution against speculation, inference on top of inference, or possibilities as opposed to probabilities. That guides the court's analysis as to whether it looks more like the diary entry or more like the rifle. And that's not even complete, Your Honor. I guess that's the most important point, because that is only for admission as gang affiliation and identification. It doesn't it doesn't present the constitutional concerns that it does as testimonial evidence. When we're talking about testimonial evidence, by definition, that raises constitutional concerns, and it's more than just a mere foundational, claim. And so, I would urge Your Honor to take a look at least the section in our brief that raises the constitutional issues here, because this is, by definition, testimonial evidence and raises constitutional concerns. And last, Your Honor, I almost didn't get to mention, and I apologize, but because the barrel is sort of the big thing here, but you have the issue of the two. What's the term? The semi-automatic and just the picture of the muzzles. Thank you. Picture of the muzzles. That is definitely the rifle. So you just got two muzzles. Now how in the world is a picture or a tattoo, I wonder, of two muzzles? How does that get you to, this is an admission, this is testimonial that I did something with these muzzles? And that's one. And then two, God forgives. Once again, God forgives what? God forgives whom? God forgives the individual. God forgives man generally. God forgives us of our trespasses as we forgive those who trespass against you. It invites the very sort of speculation that Massachusetts courts eschew. Now, so in terms of two muzzles and God
you're
forbid,
looking at them all one at a time in isolation. And isn't it appropriate to consider that they were all selected and sought at the same time?
Your Honor absolutely can consider that. And
it's a way of saying, Mr. Sullivan, that doesn't the cylinder of the revolver and the 5 shells that are depicted, the one empty chamber, take on some meaning, or can't you imbue it with some meaning by virtue of the reverse lettered God forgives tattoo right above it? Assuming that one finds that the defendant is the one that selected that depiction, directed how many shells are to be shown, or that at least one chamber be empty, and instructed as to the reverse lettering of that tattoo. Assuming the defendant, in fact, directed those features to be inscribed, then isn't it appropriate to view them in combination?
I think that's a great question. Two answers. Yes, you can and should view it in combination, as well as viewing it singularly, because they're coming in as singular pieces of evidence. The verb Your Honor chose in asking the question, I think, is both relevant and telling, and it is imbue. And when we have to go through these active practices of giving things meaning, then we are crossing the line into the sort of inference on inference and the sort of speculation that Massachusetts courts guard against. Three, and just Your Honor, Your Honor asked, the Ochoa Court was affirmed by the Supreme Court of California.
Thank you.
And I thank my able law student for checking that very, very quickly. And finally, Your Honor, so if we are going to judge them in toto, there were other tattoos done on the same day, blood, sweat, and tears, for example. Most gun tattoos...
was that done on the same day, or was that the defendant's other visit?
Oh, boy, the same artist, was it the same day?
The same, he testified it was the same time. It was done at the same time.
So, yeah, at the same time, that appears to be our collective recollection of the testimony. Most gun tattoos, tend to indicate I'm not giving up. Oh yeah, blood, sweat, and tears, CBS, WBS, SJ for his fiance. It's so if the court's going to look at them in toto, then the court should look at them in toto and not wrench out the context of 3 or 4 tattoos that tangentially fit a theory of the government that has not, at least yet, been borne out in testimony.
Okay.
Those are essentially our argument, Your Honor. And if the court, I didn't plan to talk this much, but if the court has any specific questions, I'm happy to engage.
No, you've submitted a further pleading on the issue this morning, so I want to study that before I rule, but I'll bear in mind the arguments you've just given. Okay, Commonwealth, do you want to be heard?
Your Honor, I'll be brief, and we're going to rest primarily on our prior submissions. It seems to me, however, given the court's ruling and order, that one factual foundation seemed to be at issue, which I believe we resolved today with Mr. Nelson's testimony, and that was really the circumstances under which the tattoos were obtained. I think Mr. Nelson's testimony was pretty unequivocal about the fact that Mr. Hernandez made all the relevant decisions with respect to the locations and what was to be depicted. While there might have been some conflicting testimony regarding whether Mr. Hernandez actually used the word a 6-cylinder, what was very clear was that visually the two of them agreed on an image that came from the computer, and that was the basis upon which the tattoo, at least of the cylinder, was put on Mr. Hernandez. Same with the muzzle of the semi-automatic weapon, which was depicted based upon Mr. Hernandez's selection of the image from a computer. So based on the evidence that came before the court this morning, it appears that Mr. Nelson had absolutely no discretion that he exercised with respect to this sitting with Mr. Hernandez regarding the tattoos. And I think that was the factual foundation that appeared to have been at least ambiguous or missing from the prior submissions. Otherwise, I think the law as we outlined it, we would rest on the argument with respect to the law. I think this is really more of a factual issue for application to the law.
All right. Let me review what's been filed this morning by the defense on this issue and consider the testimony. We'll see you all in the morning.